Hi everyone, welcome to today's webinar. We're just going to let the Zoom room fill up. So we've got plenty of people here. We'll get going in a minute or two. You're all very welcome to today's session. Hi everyone, welcome to everyone who's just joined us. There's hundreds of you queuing up to get into the Zoom room. So we're going to give it a minute or two just for that to fill up before we get going. It's great to see so many of you joining us today. Okay, I am going to get going with some of the webinar housekeeping. Good afternoon to those of you who are just joining. Welcome to today's webinar. I'm Anna from the TUC, and I'm joined by a very special guest from Thompsons Solicitors. It's Daniel Poet. You'll be hearing from him shortly. He's a partner at Thompsons and a national lead for workplace disease. We're just going to run over some housekeeping before we go. So already I can see many of you introducing yourselves in the chat panel. Please tell us your union, where you work, and anything that might be going on in your workplace that is on this subject, because we always like to hear from you. We are going to be asking you all to get involved in this webinar as well. And shortly, we're going to ask you some questions, and we're going to ask you to put the answers in the chat. And it's not a test, don't worry. There's not like going to be marks, but we just want to hear about what is going on in this area for you. We do, of course, have live captions on this webinar. So if you want to follow along with those, the CC button, which is under the videos at the bottom of the screen, has those. We're recording this, as we always do, so if you miss anything, don't worry, we'll send you a link to the recording. And if you've got any questions for me or for Daniel, please post them in the Q&A panel, which again is at the bottom of the screen, and we'll try to get to those after we've heard from Daniel. So today we're going to be talking about workplace illness and workplace disease, and we're going to be getting answers to some key questions from Daniel. So I'm going to hand over to him now to get us going on this with a brief intro before we ask you some questions.
Thanks, Anna. Hi, everyone. I can see there's over 200 people in, so that's fantastic. It's I'm trying to think if I've ever done a session to this many number of people. It's normally sort of a handful or in a room, dusty room somewhere. So it's quite nice. But yeah, thanks for the introduction. So there's a couple of things that I guess we want to cover today, sort of in broad terms. The first one is to look at, well, when we talk about a workplace illness, we sometimes refer to it as occupational disease. What are we talking about? Okay, as distinct from an accident, which is sort of fairly self-evident. So what are we talking about? What are the types of cases we're talking about? What are the types of hazards that you know, some of your members and colleagues are going to be faced with? And then the second half of it is really focusing on, from a legal point of view. I come from a exclusively claimant background, as you can imagine. We don't act for any defendants, but I've only ever done claimant work at Thompsons. But what do we need to prove in a practical sense, with a bit of a focus on the specific issues with workplace illness claims? And I guess the most important thing from your point of view is, well, what practical help can union reps be sort of on the ground to make sure that we absolutely maximize the members' prospects of success? Because as a personal injury lawyer, it's a strange position to be in, because ultimately we don't want people to be injured. We don't want people at work being injured by any of these things. Now that might mean perversely that the likes of myself will be out of a job, but you know, that would be what we're all going for, right? That's why we have these things. That's why we're union members, because we want to, you know, people do not deserve to be injured simply through doing their jobs. But the second half, as I say, is focusing on, well, what do we need to prove, and therefore what practical things can union reps do to hopefully maximize your members' prospects of success, because that's ultimately what we want. If they're in the unfortunate position where they do need to make a claim, We want them to win ultimately. Okay, so if we start off, as Anna said, there's going to be a couple of questions fairly near the start. I'll do a very basic introduction. So, Yusuf, we can look at the next slide. Just really dealing with the real sort of nuts and bolts of, well, what are we actually talking about? What is the kind of basic distinction between a workplace illness and an accident? Now, fairly self-explanatory, but what is an accident? Well, an accident we can describe any number of ways, but an immediate bodily condition resulting in a one-off traumatic incident. So what we're ultimately talking about is, as exactly as you'd imagine, it's a traumatic incident that happens in a moment and ultimately causes an injury. So a few obvious examples there, but the types of things we see at Thompsons all the time would be manual handling type injuries. So a one-off lift, manager says to you, right, go and move this 40-kilogram thing with no assistance, try and lift it, your back goes, whatever it is, your shoulder goes. Slips, trips, and falls again. It's a one-off traumatic incident where you slip over and you damage some part of your body, whatever it is. Machine accidents, there may be a guard missing, whatever it is. So you might be using a machine without a guard and injure your finger, clearly an accident, road traffic accidents, etc. So one-off traumatic incidents. Now, workplace illnesses in a very, very sort of a broad brush way you can define as injuries that occur essentially over a period of time. So that it might be that they're exposed to a trauma of some description at work, but what we're talking about is something that's built up over a period of time, or at least the exposure has been over a period of time and maybe caused an injury much later in the day. So we'll touch briefly on these, but some injuries will have what we call a latency period. So you might be exposed to something for 1, 3, 5, 10 years, whatever, and the injury then manifests itself later on. That's a workplace illness. It's an occupational disease because it's not a one-off traumatic episode. Okay, so the definition I put here is, just to sort of expand it briefly, a condition that results from exposure in a workplace to a physical, chemical, or biological agent. I put in there even psychological. Okay, and we'll come on. I don't want to sort of elaborate too much because I say there are a couple of questions over the page, and we want to sort of maybe gauge to what extent you've got some experience in this stuff and have some background in it. But it can almost be exposure to anything. There are any number of hazards within the workplace depending upon what you do, and those are a few sort of examples. And as I say, in the later slides, we will go into a few in a little bit more detail. They tend to be cumulative in nature, as I say, so stuff that's building up over a period of time. They importantly, and we'll talk about the medical evidence and what we call the causation part of any claim later on, which is a really important part of any occupational illness claim. But they very often you will see members who have got conditions which might be common constitutional conditions, and a big part of the battle as the lawyers is to say, well, hang on a second, this wasn't just going to happen anyway. Yes, it does in some people, but because of what this person has been exposed to, we say on the balance of probabilities that it wouldn't have occurred in any event, or if it would, maybe it wouldn't have occurred for 5 or 10 years or 15 years. Okay, so you have all these sorts of arguments based on the medical evidence, and we'll get into that a little bit later. But it's a very it happens with accident cases, but it's very much an area where disease cases and occupational illness cases have a real battleground, as you can imagine, because often they're not as clear cut as an accident. Because if you slip over, trip over, have a car crash, and you go into A&E and you've got a broken ankle or you've got a twisted knee, whatever it is, an expert in the context of a case is not going to have any difficulty linking that, because they'll probably have an accident report form where they know that somebody twisted their ankle, or they know that somebody immediately went to A&E and had an X-ray. It's all very straightforward, and no one is going to suggest that person would have broken their leg or broken their finger or sliced their finger or whatever it is in any event. Now, with disease cases, you almost always have those arguments, because inevitably, I don't know if there's a cross section of people on this call, but certainly from my point of view, you get to a certain age, the aches and pains come in, and people develop this stuff, and it's our job as lawyers, by way of the claim, to try and convince a medical expert and ultimately a court to say, well, actually, it's actually this workplace hazard that has caused, or at least materially contributed towards, this injury. Couple of other points there before we go into the questions. So worth noting, with occupational illnesses, there are some which are divisible, and by that it means you can have exposure at more than one employer, and the damage builds up. So the amount of trauma that the person is exposed to builds up over a period of time. And I've mentioned a couple there. Now, I won't go into them now because that slightly gets ahead of the next question, but I'll talk about it in a couple of slides. Halves people may be aware of. And that is an example of a divisible injury, and I'll talk about that in a minute. A rules claim is what we might call an RSI, and again, I'm slightly giving away one of the answers to perhaps a later question, but that's an indivisible injury. So a repetitive strain type injury, you're only interested in the work that that individual is doing at the time they develop their injuries. So it doesn't matter if they did a similar job at a previous employer, it's irrelevant. It's about what you were doing when you developed that injury. And you don't have to look at previous employers, and it's not divisible in that way. So as it says there, one other point to make, and we'll talk about what we mean by limitation in a moment, but a particular issue with workplace illness claims is that because they build up over a period of time, often months, sometimes years, it can lead to what we call limitation difficulties. And I'll talk about what that means in a moment. But ultimately what it means is the time limits that apply to personal injury claims. And you may or may not be aware of those, but they're fairly strictly enforced. And it means that disease claims, we often have arguments that claims are out of time. And as lawyers, we have to decide whether or not we're going to win those arguments. So all of that's very much, as you appreciate, a very sort of broad brush, speedy whip through of kind of the sorts of things that we're talking about with illness claims. But hopefully that gives you a basic idea as to the general distinction between an accident and a workplace illness. So if we go on to the next slide, that's where we've oh, sorry, my mistake. We've got one more slide of limitation. I'll deal with that, and then we've got the questions. So I touched upon it a moment ago. So by limitation, what we mean, we often call it limitation, and we tend to fall into this bad habit of using legal jargon. What we mean is the time limit whereby the claimant has to issue their claim at court. Okay, so the reason we call it limitation is it's from the Limitation Act, which is an act in 1980, which essentially says with personal injury claims, effectively all, for your purposes, all personal injury claims, there is a 3-year limitation date. Okay, so the reason it's important in terms of workplace illness claims is that with an accident, it's very clear cut, because if you have your accident on, 1st of April of this year, you have 3 years from that date to issue claim at court. And almost always it's been recorded. There might be an accident report form, they might have gone to A&E, whatever it is, but it's not often very difficult to establish, right, when, what date did this occur on, and then you run it from that date. Now, as I say, with workplace illness claims, you have people with a build-up of symptoms often over a long period of time. So then the question becomes, well, okay, you've got this 3-year deadline. When does it run from? Because what the law says is if you miss that deadline as a claimant, the starting position is you're out of time. Okay, and they strictly enforce it. And there are certain arguments you can make as lawyers to say, well, actually, we should get the discretion of the court here. But they are few and far between. And so as lawyers, one of the first things we do whenever we're speaking to a new client, a new trade union member, is to try and establish, right, what is limitation? And it's a lot more difficult with disease claims. So what are we thinking of? Very, very briefly, I mean, I could bore you to tears with limitation, and we could do 3 hours on that alone, which I won't do, I promise. But what are we looking for? Well, what the law says with diseases, it's the date that you knew or you ought reasonably to have known. It's what's called a reasonable person test, like an objective test. It's not what you did know, it's what you ought reasonably to have known. That a third party was responsible for your injuries, and that they were significant at the time. So you have a question mark as to what's significant. Now, with disease cases, what that means is, if you've got, for example, a back injury that's building up over a period of time, you might have the odd twinge here and there. No, great. You're not taking any medication. Don't go see your GP. Not going to occupational health. It's just a bit of a pain. Dies down after work, whatever. That's not significant. So the defendants can't then say, well, you should have rushed off the second you have a twinge in your back, and you've got 3 years from that date. However, when your injury develops and you start having clear symptoms that either you're taking medication, or definitely if you go to a GP, or if you see occupational health about it, saying, well, I've got this problem, and you ought reasonably to have linked it to work, that's when the clock runs. And so it's obviously our job to kind of assess the member's instructions and work out, right, when is this likely to run from, and are we at risk here? Because often people will come to us and the problem might have started 6, 7, 8, 10 years ago, and it's no criticism of them, but it puts us in a difficult position because we have to say to them, look, we're really struggling here. So I'm conscious of time, so we'll get on to the next slide. But the point at the bottom there is just act promptly, and we always need to bear that in mind when we're looking at the practical tips at the end. Almost the overarching message at all is whatever we do it quickly, because there's always this time limit issue in the background. Okay. So if we can go over the page on the next slide, we've got these questions. Anna, am I handing over to you now to kind of just have a look at these?
Well, what we want to do is put a few questions to you before we hear from Daniel again. So there's no, like, as I said, this isn't a test. We're not going to kick you off if you don't give the answer that we like. In the chat, the first question there, bearing in mind what you've just heard from Daniel about what a workplace illness is, what examples of workplace hazards can you think of that might result in a workplace illness? Now, they're going to start coming through quite fast, so we'll try it and look at quite a few of them. Right, asbestos is coming through straight away. Exhaust fumes, psychological issues, air quality, mental health, stress stuff, lots coming through. As you can see, Daniel, it's going forward.
Yeah. I can follow. Lots of good answers there.
Lots of good answers, yeah. Rodent infestation. Maybe we can come back to some of these.
Yeah.
Okay, while those are still coming in, I'll read out the second question to you all. You can have a thinking about that as well. Bearing in mind what we've heard from Daniel already, what do you think an example of an employer's duty in respect of hazardous work might be? So the employer's duty, risk assessment, safe system, remove the hazards. So we'll pick up on some of these going forward, but great to see that you're all thinking about the issues already.
Yeah, again, really good answers, really good widespread answers there.
Great stuff. We've got a really big range, haven't we? And finally, workplace illness examples. We've talked about what might cause them, but what examples have you got of workplace illnesses? Mesothelioma, of course, related to asbestos, stress, vibration, white finger, anxiety. Are these all good answers as well, Daniel?
Yeah, all really good answers. Yeah.
While these are coming in, one thing I forgot to mention at the beginning is that this webinar is the first in a series that we plan to do with Thompson. So today, Daniel's going to be giving us information about the process of making a claim and the rep's role in getting information as part of the legal process. But we plan to have 2 or 3 deeper dive webinars into some of the key areas of workplace illness. So some of the things that you're talking about now, perhaps there'll be something that's respiratory related, something that's musculoskeletal, and another one. We are going to get those planned in as well, so that we'll have a more detailed look at those in their own webinar. So I'll hand back to you, Daniel, to go into the answers to these a bit more deeply and the wider process. But do keep posting any thoughts that come up in the chat along the way.
Yeah, I mean that was a really really sort of comprehensive. I could sort of see him flashing up, and on all of those questions, it's obvious that you've got at least some background knowledge in this, which is great. So hopefully none of this is teaching you to suck eggs too much. But I mean, the vast majority of those answers were bang on, and obviously, what I can't do today, obviously, is touch upon sort of all the entire gamut of possible occupational illnesses, which there are dozens and dozens that we deal with. So what I've done is I've broken it down into sort of half a dozen or so, sort of probably some of the larger areas, I guess. But as Anna says, what we can do in due course is really focus and get into the real nuts and bolts of one particular area and really get into the weeds on it. So this is very much a whistle stop tour. But if we could just go on to the next slide. So a few examples there. I think pretty much all of these had had come up, I think, in the various responses. So I've done a quick, as I say, incredibly brief slide on each of those. So HAVS VWF, what we mean by that is hand-on vibration syndrome. Used to be called vibration white finger. It's a bit of an outdated term now. As I say, the slides on each of these, so I won't go into these now. Ruled means bit of a mouthful, work-related upper limb disorder. I don't know if anyone's come across that. People typically know it as RSI, which again is a slightly sort of out-of-date term now, but obviously meaning repetitive strain injury. Deafness, by that obviously occupational deafness or noise-induced hearing loss. Asbestos-related injuries, that should really say, so mesothelioma, asbestosis, etc. Huge variety of chemical injuries, depending on the chemical. That will dictate clearly what type of injury might be associated with that. But as you can imagine, there are just a huge number of hazardous chemicals that people use to one extent or another. Dust type cases or respirable silica cases, which might cause silicosis, that sort of stuff. Our old favourite, stress at work, would be a disease claim, and which is why I think I've sort of inserted as the trauma to the person being psychological as opposed to anything else on one of the first slides. But we'll touch very briefly on that. Again, I could bore you to tears with a 3-hour seminar on that if you like. COVID-19 I've put in there. I know Anna, you mentioned that. I could touch upon that briefly, and again, we can talk about that for a long time, but this is very much a whistle-stop tour. So if we go over the page, I've just literally got sort of one slide on each. It may be that, I mean, there were loads of good answers there, but it may be that some of you have heard of one or more of these, or all of them, or none of them possibly. So hand-on vibration syndrome, that's an area that I've done a lot of work in the past sort of 20 plus years. So it's a condition affecting your fingers, essentially. Even though it's called hand-on vibration syndrome, it's essentially your fingers, and it's caused through exposure to vibration. So vibration being the hazard in this case. So long-term exposure to vibration, and typically from obviously handheld power tools. Now you can have whole body vibration claims, which are things like if you're sitting on a ride on lawnmower over rough ground all day, every day, it can cause musculoskeletal injuries, and there are regulations, or at least directions in place as far as, well, how much vibration can be exposed to in that sense. But what we mostly have are hand-on vibration cases. So these are people using vibrating tools. As you can imagine, it tends to be the ones that vibrate to a significant degree. You're not going to get hand-on vibration syndrome using a household drill every now and again. It's people using these jobs regularly. So historically, we would have seen industrial gardeners. So if you're at Unison, you'll get the strimmer pilots, on the side of the verges doing that all day, every day, or hedge cutting or that sort of stuff. You'll get people at aerospace places where they've used these these rivet guns, which are incredibly high vibration, which will get you up above the what they call the workplace exposure limits and the action levels. They'll get you up above those in 10 minutes use. So anyone, but then in between you get loads of people using grinders and jackhammers, so people digging up the road. So you'll see, these companies repairing the gas mains, and you'll walk past them and they've never got gloves on, and they're and they're digging up and repairing these holes all day every day. So those are the types of people that are affected. And it affects your hands in two ways. It's a vascular and a neurological injury. So if the extent to which it affects the blood supply is why you get the white finger, which you can see on there. An example there. It'll start at the top, and you'll typically see it'll be circumferential, and you'll see a clear demarcation. If it doesn't look like that and it looks all blotchy or whatever, it's not HAVS, because it has to be that's the way that it affects you. But they'll also often get neurological issues. So in addition to getting attacks like that in the cold, you will get numbness, tingling, and if it gets severe, you can lose the feeling in all of your tips of your fingers, and you end up losing your job because you can't use the tools anymore. Okay, so that's hand-on vibration syndrome. I've just seen it. I can deal with this if you like. Limitation for HAVS is 3 years. So again, you get into that data knowledge point. That was just a question that popped up there. Work-related upper limb. So as I say, used to be called RSI. It's just people who are doing a job that is intensely repetitive and that may potentially cause you. Often, upper limb would include bizarrely your neck as well. But anyway, typically upper limb injuries, as it says there, often affecting your shoulders, arms, wrists, hands, and fingers, caused by repetition or poor ergonomic posture. That's a crucial definition, distinction rather, because there's broadly two types of cases we get. We will get people who do, say, production line type work. So they will do, often there is a process time of say, whatever it is, 60 seconds, 70 seconds, 90 seconds, whatever it is. And they will do that job over and over and over and over, which means they're using the same muscles, doing exactly the same action over and over and over. And if you get somebody at one of those production plants doing a proper risk assessment for the purposes of a work-related upper limb disorder, it should say, right, you need to rotate every couple of hours. Even if you go back in the afternoon, as long as you do something else in the meantime, you're generally okay, because your muscles can recover a bit and you can rest, etc. So that's the key. That would be the key way that you might reduce the risk of injury. We also get cases where it might not be that repetitive, but there is ergonomically a very unsound environment. So, for example, I act for a group of pilots who there is a security screen, and when everyone wants to get it, since 9/11, you have to look at a screen, see who wants to come in the cockpit. And I shouldn't say name of the defendant, but what they did was, instead of having the screen down near where the pilot can see it in front of them, they put it on the bulkhead, literally right behind them, and they're strapped into the seat. So every time they have to look at this screen, they've got to literally turn around and almost look like that. And lo and behold, they will develop neck problems. So that might not be as repetitive as a production job, but it still involves, of course, severe risk of injury. So you might need an ergonomist to get involved and say what they should have done properly, etc. Okay, so yeah, next slide. Noise-induced hearing loss or deafness. These are cases, you can get what we call acoustic shock cases, but they would come under the umbrella of an accident. And by that, I mean a one-off incredibly loud noise might cause an injury to your ears and might bring on tinnitus or that sort of thing. What we're talking about here, because we're talking about a disease, is somebody who is typically exposed to high levels of noise, not incredibly high, but a high level of noise, typically 85, 90 decibels. When you average it out over an 8-hour day. That means, are they in that environment for 8 hours in their working day where it's between 85, 90 decibels, that sort of level, and they need to be exposed for a number of years in order to be injured. Now, everyone is different, and some people will be affected differently. And again, we could do a whole talk just on noise-induced hearing loss, but that's broadly what you're talking about. So as soon as somebody comes to us and says, I've been working in a factory environment and it's 85 decibels and I've been there 6 months, you're never going to win that claim. You've typically got to get 5, 10, 15 years of exposure. The other big issue with the hearing loss claims is, as I said, it was the audiograms. So noise only affects certain frequencies, affect the higher frequencies. And what that means is, when you look at somebody's audiograms, there will be a particular pattern if noise has damaged them. It's like an inverse tick. I haven't got an example here, but it'll sort of drop down and then it'll recover typically at some of the higher frequencies which are not damaged by noise. And they're not quite sure why, but what it means is you can almost look at an audiogram, and it's not diagnostic, but you can almost look at an audiogram and go, right, this claim has a chance of winning because it conforms to a certain pattern. And sometimes they might just go straight down, and that an expert will say, well, that's just age-related loss. So you get into all these arguments about, well, this person would have lost their hearing anyway. This has nothing to do with noise. So remember I said at the start, there's often overlap between these injuries and common constitutional conditions. So you can imagine this is going to be an area where we're going to have arguments with the defendant as to, what constitutionally they may have lost anyway. So that's noise-induced hearing loss. Asbestos type cases. So what do we need to prove? We need to prove that member was exposed to asbestos, clearly, often in a workplace or other location due to somebody else's negligence. I talked briefly about latency periods earlier. Now, with things like mesothelioma, you're talking decades. So you might be talking sort of 30 plus years. And what that means evidentially is that you might be faced with somebody who says, well, yeah, I worked at this company 35 years ago. Well, number one, do they exist? And you've got to, potentially restore them to the company register, that sort of thing. But number two, how do we prove they're even exposed to asbestos? Because the building's probably gone and everyone's left, etc. Which is why the second point is so important. We have registers. So as and when asbestos is identified over the last 25, 30 foot, we make these registers so that we can then fall back on them and go, right, well, we know that there's a document relating to asbestos from this employer 30 years ago because we've got it on there and we've got this person registering it. So that's what's really important in asbestos work. you need to have a diagnosis of a disease caused by asbestos, such as asbestosis or mesothelioma, which might be sort of self-evident, but they are, very much sort of niche cases. And at Thompsons, we have a team who deal with nothing but asbestos cases, particularly mesothelioma cases. The sad fact being that most people who come to us with mesothelioma have got a very short period to live, and so we ensure that those lawyers have low caseloads so that they can immediately react to somebody coming to them saying they've had a diagnosis of mesothelioma, because you've got to or essentially prepare the case often in weeks, if not, a few months, which is obviously tragic. But so that's asbestos cases. COVID-19 cases, something I've been heavily involved in the last sort of 3-4 years. Again, could be the subject of a lengthy talk. Now, we talked about, the difficulties we have in proving injuries. I compared it to an accident at the start. So very straightforward. If you fall over and break your ankle, you're going to get an expert to support that. COVID-19 cases are by far, I would say, higher than stress, more difficult to prove causation on. Now, it depends upon when the person's infected, because if it was during one of the lockdowns, you're going to have a better chance. So if you're only going to work and coming back, and you're not going anywhere else, then you're gonna have a better chance of saying, number one, you got it at work, which is the first hurdle rather. Were you infected at work? The big question mark being, well, you could have got it in any number of places. So, for example, you might be going to work and coming back and doing nothing else. But if your spouse is also doing that and your kids are going to school and coming back, etc., you've got other possible routes of infection. You get into all the arguments about, well, did the employer provide the correct PPE, etc. And if they did, can we prove that that ultimately led to that infection? So if we can prove it was at work, we've then got to prove that whatever we are saying was the deficiency at work on the balance probabilities led to that infection, which is incredibly difficult to prove. So we're left with what we call a but-for test with COVID cases. So again, I don't want to go into the details of the various causation tests, but with disease cases, sometimes you can argue, well, if it has made what we call a material contribution to the injury, then we can recover damages. And that's what we call any contribution that's more than de minimis, so more than an absolutely negligible amount. Now, with this, because COVID is a dose, you get a dose of it. We're saddled, unfortunately, with the balance probability tests, and it's just incredibly difficult to thread the evidence through that, eye of that needle. So that's COVID case, but it's another example of a workplace illness that would come under that sort of broad umbrella. The final one over the page is occupational stress, which I know came up in some of the answers, and bullying and harassment claims. There's a few bullet points there that are kind of useful in terms of sorts of things we look at that are relevant. So what's the HSE guidance? Is there a stress policy in place? Are there risk assessments? The reality is, with stress cases, there's really two types of claims that can succeed, and there's a very important reason for that. The first are, if we might call them, generic overwork cases. So somebody who is, working two people's jobs and working 90 hours a week, etc. There's a slide later on dealing with what a legal concept called foreseeability, which is what do we have to prove the employer should have been able to foreseen for them to be liable. Now, generally with personal injury claims, we only have to prove that they should have foreseen an injury. It doesn't have to be the injury, just an injury. It's got to be reasonably foreseeable to them. Now, what the case law on stress claims says is, no, we're going to put the bar a lot higher than that. We're going to say that the claimant has to be able to prove that they could foresee, that the employer rather could have foreseen a recognized psychiatric disorder developing. So an actual disorder, not that it's not, it's not enough to say, well, they should have foreseen stress, some anxiety. It's a much higher bar than that. And the reason the courts have done that is because they don't want to be flooded with stress at work claims, is the reality of it. And the case law actually says in there, we think that a lot of people thrive on stress, et cetera, et cetera. So the bar for stress claims is right up here. So with an overwork case, what you're looking to do is say, well, look, either I've been off work first and I've suffered an injury, and I came back and nothing happened, and therefore it's called a second breakdown case, and then I went off again. So you use the first absence to say, look, you cannot deny you knew that they were about to suffer recognized disorder because they went off with stress or an illness, came back, didn't do anything, they've gone off again, now they're off long term, and you claim for the long term bit. the other type of case is what we might generally call bullying and harassment cases. So again, there is a particular act which is brought in for stalking, which I haven't referenced here, called Protection from Harassment Act. So that's often how we run those cases. But again, the conduct we're talking about has to be really, really serious, and that's not to downplay stuff that happens at work, which can be really unpleasant, but it's got to be almost criminal in nature. That's what the case law says. The type of thing that the police would investigate. So, serious racial element to it, maybe a sexual element to it, or really concerted effort to target and bully someone. So what we're not talking about are unprofessional, unpleasant managers, personality clashes, that sort of stuff. So they're very complicated claims because they'll come to us often with lever arches of notes, etc. And you've got to kind of decipher your way through it. But anyway, the point is stress and those claims form part of a very important part of workplace illness work. Okay, I'm slightly conscious of time, so if I go over the page, and I just want to, the next sort of part of it is really practical kind of elements, I suppose. So slide says, how do we assess a claim? I've touched on a lot of these issues, but just to boil it down, we're the claimant. It's our burden to prove these elements. Now, this goes for accident claims as well, but in workplace claims, often these are more difficult. But the burden's on us to prove each of these, and we can't prove, two or three of them and not the other. We have to prove all of them, or else it fails. Okay, so we've got to show there's a duty of care. Now, often that's straightforward because almost always, most of the time, it's the employer who we're looking to pursue, and the employer will owe the employee a duty of care. So that's not an issue for us. Breach of duty, we've got to show they breached that duty. So depending upon the workplace, which type of illness you're talking about, there will be a framework as far as, well, what do we need to show? So how much vibration should they really be exposed to before they start rotating them, or that sort of stuff. Should they be exposed to this chemical at all, or can they, or there might be a workplace exposure level, that is the kind of line in the sand legally that we've got to show that they were over. So that's the breach of duty, the fault element of it. We've got to show the breach caused the injury, so causation. That's where the medical experts come in, and there's a separate slide on that in a moment. And as I touched on a moment ago, that the injury was foreseeable. So broadly, putting stress to one side, we only generally in personal injury work need to show that there was a foreseeable risk of an injury. Doesn't have to be the one, but just an injury. Okay, so that's the background, and we've got to show each of those elements. So duty of care I've touched upon. I think we could probably just on the next slide, we could probably just flick over that one actually, because that's it says there road users owe duty of care. Well, that's in obviously an accident context. That's really applied to workplace illnesses. Breach of duty, few examples here. So we've got kind of a two-pronged approach. Now, I've got a slide in a moment dealing with what changed about 10 or 12 years ago. But broadly, as a background, how do we show breach of duty? Well, it's a number of sources. Common law is basically, the case law where the judges in the Court of Appeal, or the House of Lords as it was, Supreme Court, have looked at a particular type of case, and they've made a decision, and we can then use that and say, well, that is a binding authority. And there is any number of decisions historically on any number of different types of cases, whether it's stress, whether it's manual handling cases, whether it's whatever it is, and they will give you pointers as to how certain things can be interpreted. They have a broad common law duty to provide a safe system of work and that sort of thing. But what you really are looking at in these cases is the regulation on the right-hand side there. And that really gives you the kind of teeth and the specifics of it. So I'm sure you've all come across half of these regulations: manual handling regulations, workplace regulations, personal protective equipment regulations, display screen regulations. There are a load of others. COSH is an obvious one, so deals with hazardous substances, and management of health and safety regs. So all of those set out in a lot of detail things that employers should be doing in certain types of situations. And that's the kind of starting point when we're looking at breach of duty. Can we prove that they've dropped the ball in one or more of these areas? So that's the breach of duty side of things, the fault element. Quick slide on causation over the page. So what do we mean by causation? It's medical causation. So we've got to get independent medical expert who has the appropriate authority. We have to get a medical report from them saying, on the balance of probabilities, is there a link between any breach of duty we can establish and these injuries? And if we can't get that, the claim fails. It doesn't matter how egregious the breach of duty is. You can expose somebody to the most horrific chemicals, for 10 years, but if they haven't got the correct injury, as it were, and the medical expert says, well, this is nothing to do with these chemicals, your claim fails at that point. You've got to have that. You can't have a break in the chain, as we call it. So as it says here, it's almost, not always, but often straightforward in accidents. With diseases, it's often where you have the argument. It's often not breach of duty, which quite often is straightforward. You're often arguing about the medical evidence. Over the page, enterprise and regulatory. Now, the reason I don't want to bore you with this stuff too much, but the reason this is so important is that prior to October 2013, all of those regulations I've just referred to, as lawyers, we would be able to specifically run a case and say, right, you have breached this regulation of the manual handling regulations, and that is our cause of action. And we would run the case on that basis. And they were a lot of those regulations were very, very what we might call claimant friendly, and they were very onerous on employers. So they were really helpful as lawyers. And what the government at the time, effectively lobbied by insurance companies, did was just completely change the law and say, right, you can't now effectively run a case off the back of one of those. You can use them as kind of guidance, but you can't run a case off the back of those. So you're now left with proving what we call common law negligence. So we're going back, effectively turning the clock back 60 years. And what that means is there are certain cases when the regulations are in play that we would always win. The best example is work equipment cases. So prior to October 13, the provision and use of work equipment and under the case law that I just talked about was absolutely clear cut. If you were at work and you used equipment that broke whilst you were using it, it's defective, and the employer was automatically liable. It's what's called strict liability. So it wouldn't matter if they checked it 10 minutes before and it was fine, and there was a latent defect, they would be responsible for that. Now, we're left with common law negligence. We have to prove that the employer was aware this was going to be an issue, and so if they had a decent system of inspecting now, they would escape liability. So if they can say, well, hang on, we check this tool, I don't know, once a week, and our last inspection it was absolutely fine. That's reasonable. They would defend that claim now. So you literally overnight had cases that you couldn't lose to you probably would lose, literally overnight. So we're in a much weaker position thanks to the then government and the insurance industry, unfortunately. But what it really means is, this is probably the main thrust of the second half of this talk, is it's so important to get our paper trail sorted out in terms of complaints, accident reporting, health and safety minutes, all that stuff, because then you can use it to show, well, no, it was foreseeable because, so-and-so complained 3 months ago and so-and-so complained again a month ago, etc. So the reason I kept that in as a slight technical point is that it feeds into the other the practical things that you guys could do as on the ground, as it were. Right, foreseeability. I think that slide I've probably dealt with actually broadly, and I'm conscious of time. So the last 3 or 4 slides, it's really, as I say, is focused on what steps can we take. So taking all of that we've just sort of admittedly whipped through pretty quickly, but if that's the background, what can be done kind of on the ground, as I said at the start, to maximise your members' prospects of success. So as it says here, unions have the right to appoint health and safety reps, and crucially, the health and safety rep has the right to investigate, make representations, and carry out inspections. Information must be provided by the employer, and you've got a right to form a safety committee. So over the page, there's a little bit more detail on that. What do we mean in practice? Well, clearly attending health and safety minutes and keeping notes. As I said before, it's so important that any what seems to be a health and safety issue that seems to be developing at work, even if it hasn't injured anyone, is recorded in these types of meetings, because it allows us as lawyers to then say 3 months down the line, well, hang on a second, you did know this was potentially a problem. Because otherwise the defendant just says, well, we've never had a problem before. This is out of the blue. We've got a reasonable system of checking this stuff. There's nothing to see here. So it's so important that is, for example, minuted, and if there are near misses, that sort of thing. So as it says here, beware of the accident book and near misses. Now we're talking about workplace illnesses, but the accident book is still something that applies, because people still, maybe it might be where they put a complaint or what have you. Keep a note of all complaints and the replies received. I mean, my experiences in the last sort of 10-15 years, employers deliberately make it more difficult for people to find things like accident books and complete them, and it might be hard to get on a work computer to find out where on earth you're supposed to log this stuff, and that's deliberately so in my experience. But if you can't, then just start your own log and say, this is what was said, and these are the dates, and then you take it to your health and safety meetings. But it's not just complaints and health and safety meetings that we can minute. Make sure you can have an active involvement in risk assessments. So make sure that they, as it says, that they take place and they're effective. So I think that was one of the answers when we asked the question near the top about, well, what obligations does the employer have? Well, they have an overarching duty to make suitable and sufficient risk assessments of anything in the workplace that can involve a hazard. And so if something comes across your desk where, someone's brought it to you and said, well, look, this is going on, then see if there's a risk assessment in place. If there isn't, then you can take steps to try and get one, get one addressed. And then if they don't do it, you've got that paper trail. You can say, well, we had a risk assessment been done when we told you it needed to be done, it would have probably identified that you needed A, B, and C, or we needed to do this, that, and the other. So risk assessments are really, really important, and hopefully you will have sort of at least some sort of training in the sorts of things we want to look at. And that's not for today, but it's just to flag up, why they're so important, I suppose. So as it says there, if you're very concerned about an unsafe practice, but the employer's not responding, you can contact the HSE. The HSE can be brilliant. They can be really slow, and there are certain stances they've taken in the last in recent years where I don't think they've covered themselves in glory, but we don't want to get into that now. But it can serve a purpose, and the HSE can be brilliant. If you get a case where it's been reported to the HSE and maybe they've visited the company, they've issued an improvement notice, or they fined the company, that's obviously fantastic evidence. I had a hand over vibration case recently where they do exactly that. So I had a defence in saying, well, we risk assess this stuff, and they're all below the limits, it's all fine. And the HSE had gone in the background and absolutely thrown the book at them, and then they capitulated. So a couple more slides. There's one on risk assessments there, which don't particularly need to go into in any detail, but identify the hazard and the likely harm, evaluate the risks, and record the findings. As I say, that could be a separate talk on its own, but you probably got at least some background in that. We can revisit that in other talks if we need to go through that in some more detail. But that's something you could definitely be involved in. Then over the page, last couple of slides, we come to, well, what there's certain things we can do before the injury, but if we get to a situation where unfortunately the member's been injured, then what do we do? Well, there's a number of things that we need to be doing, and I would say the overarching message is whatever we do it quickly, but also do it accurately. And probably the second one is more important. So if, for example, we certainly want to be completing an instant report form, even if we're talking about workplace disease, get it recorded, or you might have seen these report of a dangerous incident forms, the RIDDOR forms. Get those completed, but make sure they're done accurately. I'd almost as a lawyer, I'd rather there was a bit of a delay, but then it was done accurately, because what you don't want is they're done quite quickly in a bit of a rush, and it doesn't reflect exactly what's happened, and the other side can say, well, hang on a second, your case doesn't really marry up here. Now, that happens more so in accident cases. So the typical thing might be maybe somebody has, slipped on something. So our case on liability is they've slipped on a spillage that wasn't cleared up, let's say. And if you get an accident report from later on down the line that says, fell over or lost footing or whatever, just because it's not deemed important, we just want to record it that they've injured themselves and they've gone to A&E or whatever, we have a massive problem, because our breach of duty is that spillage wasn't cleared up in time, and ultimately it was the liquid on the floor that caused the person to fall. And if there's an absence of that there, it allows the other side to say, well, you can't prove your case, because remember, the burden of proof is on the claimant. We have to prove our case. So the contemporaneous documents at the time of an injury and what they say has huge, huge weight. It's much more impressive to a judge than a witness statement prepared by somebody, often 18 months after the fact, saying, well, no, this is what happened. Don't worry about these documents. This is what happened. So the sort of things we want to know about: if there's equipment involved, what equipment was it? some of these are more aimed at accident, but were there guards in place, undue work pressures, protective equipment available? In some, in a chemical case, you clearly want to know, well, what chemicals you were exposed to. Was there, had there been complaints about PPE? What were you given a respirator, but you weren't given face, fitting. It wasn't fitted to your face properly, so it's ineffective. What training was provided? Often you guys will know, typically kind of, what's been given. We will routinely get served with a big list of training things that looks really impressive, and then you realise that about 30 of them are on the same day, and manual handling took 3 minutes, and there was no practical demonstration. So it devils in the detail with all that sort of stuff. Just over the page, a couple more points. So witness statement. Again, really important to get a quick witness statement if at all possible. Now, that to some extent that's our job as lawyers, but it's so much better to have a contemporaneous, statement where the events are fresh in that person's mind. Photographs are absolutely brilliant. In a lot of cases, if they're relevant. So I can think of a recent silicosis case where the defendant was denying everything and said, well, no, it's not a particularly dusty environment, we don't accept this, etc. And the union rep had taken a load of photos of typically what the environment looked at, and it was, there was a carpet of dust everywhere. I mean, it was so obviously the extraction was clearly not working. There was no water suppression as they're supposed to look at, and it was so obvious that they clearly weren't doing what they say they were doing in their paperwork, and they just admitted breach of duty. But if we didn't have those photos, we'd be going to trial in front of a judge, and it'll be he said, she said. So it puts you, it makes a massive difference. So photos, sketches, you're allowed to do all this stuff, so don't be told by the employer that you're not, because you are. You can get copies of all the relevant documents. It's so useful when we get a case through if the union can say, right, here's most, if not all, of the key documents, the applicable risk assessment, the incident report form, history of any complaints, because then we can immediately give more accurate advice to your member, rather than say, well, look, we think you've got a case, but we've now got to wait 4 months to maybe the other side to give us those documents. The last point, previous accidents, we kind of covered, near misses, complaints. I think the last slide is actually a duplicate apology. So again, that's very much a whistle-stop tour through the stuff. Hopefully there's, you picked up 1 or 2 bits from that, and it gives you at least a basic flavour as to what's involved in workplace illness claims, and your role in that. And as Anna said at the start, we can look at kind of more bespoke sessions on stuff that particularly interests you, at a later date.
Absolutely. Thank you so much, Daniel. And I let you run with that rather than us sort of move on to something else, because I think it was really interesting, incredibly helpful. And a lot of the comments in the chat were saying, people really gained a lot from it. You, the audience, have posted quite a lot of questions, and we're not going to be able to get to all, but to any really other than 1 or 2. But what I've decided to do is take note of all of these questions, and we're going to use them to inform the next webinar that we do in this series, so that we can plan and prepare that effectively to answer some of the things you've asked us. Just a quick note, we did a few months back, we did a webinar on workplace injury with Daniel's colleague, Phil, and he gave us an overview of the process with that. So we will make sure we include a link to that in our resources so that you can sort of watch them side by side, if you like, to compare the situation. I'm going to just ask you a couple of the more kind of general questions we've had, Daniel. You've talked about like liability and duty of care. How does this work if there are freelancers? Does it change? Do they have the same kind of rights?
Yeah, I mean, if you are self-employed, but you are effectively working for a company who is controlling your work and supplying your work equipment and telling you where to go, etc., but you're maybe self-employed. We see this quite a lot, for example, in silicosis cases. They will often be self-employed, and you have these issues, might be even cash in hand. But broadly, the obligations are the same in that situation. Now, there'll be arguments as to whether or not they're employer-employee, but we typically would run those in the same way. Now, it becomes more difficult if they're flitting around between lots of different people, and it's only 1 day here, 1 day there, 2 days there, etc. That becomes tricky because not least they're going to have been exposed to a lesser extent, and so it might become a bit bitty. But Now that's different to someone who is genuinely self-employed and working for themselves, clearly, and ultimately they're responsible for themselves, But if you're a freelancer, but you're working a contract for 3 months for somebody, then that would be somebody who owes you a duty of care, if they are controlling your work and telling you what to give you your equipment and all that sort of stuff. Yeah.
Thanks, Daniel. That's really helpful. And you covered really helpfully towards the end of the presentation there about things reps can do in the workplace that will help with a legal case a bit further down the line. And one of the things you talked about was getting information from the employer. We've had viewers say that in their experience, employers they find employers don't like providing this. It can be a real struggle. So what tips and advice have you got for reps getting that information? Like, are they entitled to it under the law, or what other things they can do to actually get the info that they need to pass to you?
Yeah, I mean, they are entitled to see, unless there is, I mean, sometimes employers can say, well, it might contain, sensitive information in certain situations, or they sometimes try and argue it's commercially sensitive and this sort of thing. But in broad terms, they're entitled to it, and they should. Often the employer doesn't necessarily appreciate that, and so my experience, when they push back and say, well, actually, I'm legally entitled to this under the Health and Safety at Work Act, then they often go, oh, okay, I didn't realize that. Now, if they don't produce it after that, then you really want to be looking at whether you might, in conjunction with the individual, lodge it as a formal grievance, because then it gets in front of somebody else's desk, and you often get a response that way.
In these cases, is GDPR ever an excuse?
I mean, GDPR is such a tricky one because it sort of says its tentacles in most things. But if it is a generic, for example, well, if it's an accident report form and you are helping a member and it's their accident, there's no GDPR issue. And if they're trying to suggest there is, well, what is it? Ask them. And okay, if they want to, redact a name on it, not really concerned about that. But the thrust of it should be there. Same thing with if it's a work process and it's a generic risk assessment. Well, what's the problem? It's only going to say who completed it. Well, why is that? Something needs to be redacted. But if it is, don't really care about that. I just want to see what it says, because you want to see what risk it's identifying. What are their internal policies? So we can judge it against what maybe they should have been doing, or it may be a perfectly all signal dancing risk assessment, and we use it to beat them over the head with it, because we say, well, look, your own risk assessment says you need to do A, B, and C, and you didn't do it. So that's our key document. But yeah, just push back on them. You normally get it. If look, worst comes to worst, and there is a genuine claim there, we'll get it anyway, but we won't get it for a few months. So, but generally they do, I find anyway, they do seem to play ball when you push back on them.
Thanks, Daniel. And just to sort of round up and finish now, a question from me. Our viewers today are going to be workplace reps or health and safety reps. What are the three main things they should take away from everything you said today about workplace illnesses and supporting members?
Right. Okay. Three main things. Firstly, if anyone even has an inkling they might have been injured at work, unless we're generally talking about really, really low level, sort of, non-significant injuries like a niggle that's gone away or whatever, I would encourage them to get some advice. So, depending on which union it is, I mean, we act for, most unions, but whoever the panel lawyers are, get them to get a claim in, because even if we say to them, look, at this point, at least there's no claim, or we don't think it's viable for this reason, at least they've got that advice, rather than sit on it and then you might have a good claim, but then you come to us too late and we say, look, if you'd come to us 3 years ago, we'd have been able to do something here. So encourage members to get legal advice, I think, is one. Get everything you do, get it down in writing and have a good system to access it, because you know what it's like, especially if it's maybe just a bond email, they didn't prefer to either, they're very difficult to find. So I would say, if it's possible, even a hard copy of whatever key documents, anything that relates to health and safety at your workplace, keep a hard copy of it. So health and safety minutes, all that sort of stuff. So keep copies, because they disappear off. Employers can never find them. You did with insurance, say, well, they can't be traced, and for well that they're just not properly. So keep copies and make sure whatever you do document, you do it accurately, as I said before. So as much detail as possible and accurately, and get the member to sign off and say that is accurate, as opposed to a summary, which can cause an evidential problem later on when we're cross-examined on it. So, well, hang on, this doesn't tie in with what you're actually saying in your claim. So those are probably the kind of the main things I would say.
That's fantastic, Daniel. The whole hour has been great, and those top three takeaways really useful as well. So we've sped through an hour, so it's time for us to wrap up. As I said, we will be doing more on this over the coming months, doing some deeper dives into the specific illnesses and into the processes as well, possibly with Daniel or with some of his colleagues from Thompsons in their specialisms. We will be having another webinar next week about page release and facility time for you all as you're in your role as reps. So do sign up for that. And of course, don't forget, you're never alone as a workplace rep. We have a website called Union Reps. It's unionreps.org.uk, where you can join that community, post a workplace question that you might have, and get advice from other reps. See if they've had a similar issue. They might be able to help you out. You might be able to answer someone else's question. Do join. We'll put the link in the chat as well, and we'll make sure it's included when we send you the recording and the other resources. So thank you all for joining us today. Thank you, Daniel. You've been fantastic, and see you all again soon. Bye for now.
Thanks. Bye.